because this is remarkable. This is new and remarkable, but also there's so much more to remark about it that really nobody pays attention to. The company behind this lawsuit, Strike 3 Holdings, and there's another company here, Counterlife Media. I'm going to be talking mostly about Strike 3 Holdings, but Strike 3 Holdings is responsible for over 19,000 federal copyright lawsuits in the United States over the last, I think it's 8 or 10 years. They have sued over 19,000 defendants. There's 19,249 lawsuits currently in the federal court system. But we're talking about the most litigious company, copyright-wise, in the history of copyright. I don't think there's any other company or plaintiff, conglomerate, nothing that has sued 19,000 people. I know there's been some mass Doe lawsuits, but I don't even think those added up to 19,000 for any one particular company. Maybe they did, but I would say this is the most litigious company by far. And they normally sue individuals based on piracy allegations, very specific piracy allegations that someone used BitTorrent protocol, software that uses the BitTorrent protocol, connects to BitTorrent peer-to-peer file sharing networks. And the problem with file sharing or piracy on BitTorrent is that BitTorrent by default shares as it downloads, and in sharing, it exposes the IP address that is being used to do the sharing. This company, Strike 3 Holdings, typically files lawsuits, like I said, 19,248 of them, against individuals based on seeing infringement on BitTorrent networks. They capture the packets, they capture the internet data on their internet connection. They don't infiltrate your internet connection. There's no hacking or malware involved here. Not like that. Instead, they simply log their claims. They claim that they log all of the information necessary to make an evidentiary showing in a copyright case in federal court. Well, now they have filed a lawsuit not against an individual for what I think is the first time in the history of these lawsuits. They have filed against Meta, claiming that Meta, the company, downloaded so many of their videos that it must mean that Meta is using their videos for training large language models. So this is really remarkable, and I thought we should go through this and see what the claims are. I also have all of the exhibits, which are mostly just lists of things, but it is 546 pages of lists of things that they claim are evidence of these infringement claims. Would it be okay to say entire law firms have risen just to deal with the lawsuits of this one company? Yes, my entire law firm, and there are a few others. I'd say there are maybe half a dozen big players in these lawsuits, defense-wise, and maybe 100 smaller players, not meaning to be insulting, just saying there are different sizes of companies. I've represented somewhere around 2,000 victims of Malibu Media and Strike 3 Holdings, who collectively have filed 27,000 lawsuits. It's a big deal. It happens in the background, and nobody talks about it. I've had so many legal news publications, law journals, websites contact me, interview me about these lawsuits, and then they publish their story, but then it never gains any traction and no one cares. And I can understand why would you care about this. On the other hand, I'm getting phone calls every day from people who had no idea that this happens, that there's a copyright. We call them copyright trolls. Sometimes it's meant as an insult, but I mean it here as a classification of behavior. When you use the legal system to make a business profit, copyright law to make a business profit instead of using it to make yourself whole, It's more like you're running it more like a business enterprise. So it's sort of a matter of opinion. Some judges have called them copyright trolls. I have called them a copyright troll. The definition that I'm going with here is when you're using the legal system to make a business profit, when instead the legal system should be used to compensate you for harm done or damage caused. Either way, so they file this lawsuit against Meta on the 23rd of July, 2025. This is a case about ongoing wholesale copyright infringement by defendant. There's a lot of puffery in here, I'll call it. Strike 3 likes to make a big deal about how they're not some scammy company, but rather they are a legitimate plaintiff who makes award-winning works and is a very popular content creator in its field. I'm going to skip all of that. The important number we need to know is 2,300, if it would highlight, 2,396 movies are alleged to be owned by plaintiffs and infringed by defendant Meta. And the claim is that defendant Meta downloaded these works to train its large language models like Llama, especially the ones that rely on video content. Defendant distributed plaintiff's content on BitTorrent in order to capitalize on the tit-for-tat mechanism embedded within the BitTorrent protocol. It shares as it downloads. It's a requirement of the thing. They're suing in the Northern District of California because that's where Meta is located. And then we get into some of this puffery I was telling you about. We make a subscription website with high-end works, award-winning, 4K, 100 people in offices around the world, Hall of Fame, competitive, reliable salaries for employees, etc., etc., etc. Lots of awards. I'm going to skip through this quickly. Meta is a company. Meta does a thing. We all know what Meta is. It's the name for Facebook, the company that owns Facebook. I don't like the name, but I'm going to otherwise keep my opinion to myself. Meta is doing AI research. Meta invested lots of money to do AI research. MovieGen is its generation model to generate high-quality 1080p videos with corresponding audio tracks. Generative AI models take a large amount of data to effectively train. Meta does not identify what data it used. Just recently, it released V-JEPA2. Vijipa 2? I don't know how I'm supposed to pronounce that. A powerful self-supervised video world model for understanding, predicting, and planning in physical environments. Vijipa 2 trained on over 1 million hours of, quote, internet video. Meta has not specified what is this internet video. Meta released Llama 4. It incorporates video training. It analyzes and understands text, images, and videos, etc. Meta has not disclosed the training data. Recently, Meta admitted to using hundreds of thousands of pirated books it obtained through BitTorrent in Cadre versus Meta platforms, hereinafter just Cadre. I don't know if it's Cadre or I'm going to say Cadre. Sorry if I got it wrong. Internal documents revealed that Meta employees and agents downloaded 81.7 terabytes of pirated books and academic papers using BitTorrent. Okay, so now remember, what are we on here? Federal Rule of Civil Procedure 8, the pleading standard. They only have to allege what is happening and how it's connected to a legal claim and jurisdiction, which they did all that. And they will be able to survive a motion to dismiss. What we're trying to see here, when we're looking through this complaint, is there enough here that it is plausible that this is true, and the case should go forward into discovery, into pre-trial, and then eventually some kind of a judge or jury trial on the merits. The lawsuit, the Cadre lawsuit, received a large amount of press coverage. Plaintiffs became aware of Meta's infringing activity around January 2025. Plaintiffs researched its archive of recorded infringements captured by its VXN Scan and cross-reference tools discussed below, and found 47 IP addresses owned by Facebook infringing its copyright-protected works. Each IP address listed in Exhibit A shows the earliest recorded infringement of plaintiff's works from that IP address. Many of the IP addresses listed continued unauthorized distribution of multiple other works over several years. Plaintiffs confirmed each IP address belonged to Meta by using IP address geolocation technology from MaxMind. Here's an example. MaxMind IP address starting with 185 is something that belongs to Facebook, for example. Then they're going to go into what BitTorrent is, and I'm going to skip over this. Basically, BitTorrent is a peer-to-peer file sharing system created, I believe, by Bram Cohen in the late 90s. It is I would say highly efficient. I guess that's debatable depending on what your definition of efficiency is. But it's a highly efficient way to distribute large files, especially if you're willing to distribute the files through peers and not through a central server. Yes, someone has to start the BitTorrent or seed the BitTorrent swarm or stream, but then as people download the file using BitTorrent, they also begin to make available the pieces that they have downloaded. So you download a little piece at a time on a small time scale, and as you're downloading, other peers are connecting and you are making those pieces available. So you are simultaneously distributing the data that you are BitTorrenting. And unless you've done something very special, you are going to find yourself distributing. So Strike 3 uses a piece of software that they call VXN Scan that they developed. The reliability of VXN Scan and whether they can win using VXN Scan data in court has yet to be fully tested. I am one of the attorneys who tests it. I have taken them to court now 2 or 3 times, and for lack of a better way of saying it, we end up not going all the way to a trial on the merits for one reason or another. But I am prepared to test the reliability of their VXN Scan system. And apparently now they're so confident that VXN Scan will survive its test that they are suing Meta, who is obviously has deep pockets to support their defense. So VXN Scan monitors this BitTorrent activity from the plaintiff's perspective, logs this to some kind of a system, marks it with some kind of a timestamp, etc. There's more to this. I'm not going into the nitty-gritty here, because what I want to see is what are the details of how they have connected all of this to Meta. So they go back to the Kadri lawsuit. The Kadri lawsuit revealed that Meta used what it described as off-infra IP addresses to conduct its infringements so that it could conceal its BitTorrent activities. Meta employees indicated they wanted to keep torrenting activity off of Meta infrastructure so that seeders could not be traced back to Meta IP addresses. Okay. One employee specifically stated, "Not sure we can use Meta's IP to load through torrents, pirate content." Aha. Meta's employees testified that Meta configured 6 virtual private clouds to torrent content. Strike 3's tools not only capture evidence of plaintiffs' works being infringed, but also captures evidence of other activity. Strike 3 conducted an analysis attempting to find Meta's hidden IP addresses, looking for certain correlations to data patterns that match infringement patterns seen on Meta's corporate IP addresses. These are similar patterns involving mass infringement beyond what a human could consume, similar methodical downloads of disparate content based on patterns shown in corporate IP addresses, similar content being downloaded on the same day at or near the same time as a corporate IP address did the same thing, similar targeting of certain types of content, French language TV shows on the same day as Meta corporate IP addresses, etc. Correlations between Meta IP addresses where the same content is being torrented in different resolutions around the same time. They did 2 years of analysis. They provided the full raw file data, whatever that is, and they listed Meta's IP addresses in this IP address range. Ranges A to F, installed on 6 different servers managed by a major third-party data center provider. These servers are the 6 referenced in the Kadri lawsuit. So they're using some of the data from the Kadri lawsuit, I think the IP addresses from the Kadri lawsuit, and then seeing, if they did it in the Kadri lawsuit, did they do it to us too? And it looks like, yes, they did it to them too. Range G is owned by VDS Corporation, a nonprofit registered with the state of Hawaii. Okay. Plaintiffs' investigators have not been able to locate the street address for that corporation. These 7 ranges are clearly operating in conjunction with Meta's corporate IP addresses, all of which are being centrally driven by sophisticated algorithms and scripts. These correlations also quantify that both the off-infra as well as corporate IP addresses act consistently in non-human patterns, that the acquisitions of this content then must be for AI training data and not for personal use. It's interesting. Strike 3 has identified through its litigation the subscriber in control of Comcast IP address 7. Okay, so this specific Comcast IP address was identified to be infringing on using BitTorrent in conjunction with both Meta corporate IP addresses as well as these stealth IP addresses, and then they redact 4 paragraphs further of allegations. They claim 2,396 works were infringed. These are all registered copyrighted works, which means the minimum damages, let me get up a calculator here, 750 is the minimum damages. That's at least $1.8 million in damages, but if it's Meta using it for commercial purposes, the damages are going to be much higher. Let's just use 30,000 as the damage number, and you get something more like 71 million. So I don't know, it depends on what damage number you go with. You can make this sound really bad. If you want to go with the highest number, which I'm not even sure if that will apply here, the highest number that can apply is 150,000 per infringement. So that would be 3 billion. That would be 359 million. So I don't know what number you're going to actually see out of it, but that's a lot of millions for training your AI. Using adult entertainment data, videos, I don't know why they need to do that, but okay. Exhibit E contains an infringing transaction for each work. 157 of the motion pictures were infringed by IP addresses directly owned by Meta. The rest are using, I guess, these stealth IP addresses. Then they say it's intentional and willful. That's important for copyright law. You get some kind of a multiplier 2 or 3 times. I've seen as high as 10 times for the willfulness of it. How did you know that you were doing something wrong when you were doing it? Because it doesn't matter whether you meant to commit copyright infringement. If you commit copyright infringement, you're guilty of copyright infringement. The willfulness is then a multiplier on top of that. So if they are able to convince a judge or jury that this was willfully done and not accidentally done, I'm willing to withhold judgment until we see Meta's response, but I would expect this was willfully done. If it's done, it was done willfully. Meta intentionally targeted plaintiffs' works. So again, not accidentally, very much intentionally targeting plaintiffs' works. Why? High resolution, quality content, etc., etc., etc. Natural human-centric imagery. I guess they thought it was important to teach their AI what the human body looks like. There's no authorization to use the works, so they're accusing them of direct copyright infringement. Secondary copyright infringement, which is you helped somebody, basically, commit copyright infringement. Okay, so that's really interesting. It's especially interesting to me because this is my practice area. I represent defendants every day who are accused of this kind of infringement. They're not all guilty of it. I'm going to go out on a limb here and say that this is a bit of a fishing expedition where, let's gloss over the entire debate about whether the infringing activity actually occurred or not. And let's just assume for a moment that the infringing activity occurred. You still have more than one person using an internet connection in most cases. So there's always going to be some significant chance of naming the wrong person as a defendant, of suing the wrong person. And these types of accusations and the amounts of money that are involved here can be very stressful for people, as in a very bad way. It can tear apart lives. So I don't professionally or personally feel like these kinds of lawsuits handled this way is the proper way to go about enforcing your copyrights. At the same time, that's why I'm a defense attorney. So, if you find yourself on the receiving end of one of these Strike 3 Holdings lawsuits, you can call me. I have a website. Just search for my name, or you can go to torrentdefense.com, where I will help you figure out your way through a Strike 3 lawsuit, whether that means full-on litigation, which is unlikely, and more like we'll find a way to settle the case out of court, or convince them out of court that they're not going to win a case and they should drop the thing. Why litigate? Why get more blood from the stone? So I find this to be an interesting twist that Strike 3 has found. I don't know if they were even going looking for it. I think they saw that in the Kadri case, there was infringement going on and it was confirmed. And then they thought, hey, let's check our logs. And they had the evidence. I don't know if they're going to win. I don't know if the case will be settled. I have absolutely no idea where this one's going to go. Who knows? Meta may try to say that obtaining these videos and then using them to train an AI LLM, if the LLM is not being trained to produce competing content, as in to produce similar adult content, maybe it's transformative, and transformation means fair use. In other words, the purpose is different enough. You're not copying newspapers to sell newspaper articles. You're not copying, books to sell those books. Instead, you're ingesting the books and then you're going to produce an encyclopedia. That's different. If you committed copyright infringement in order to ingest 10,000 books personally as a human, and then you wrote an encyclopedia based on your research, that's arguably a fair use. And how you got the books might be a problem, might not be a problem. Walking Stick Library says, I think they are training on adult content for moderation. Okay, so now moderation would be a transformative purpose. How would it not be? Strike 3's purpose is to sell the adult videos as entertainment for adults in that specific category of things that adults like to do. Meta, if they're training the LLM for content moderation, that's not the same purpose. That's not even close to. It's a entirely different category, world, universe, everything. I could almost agree with it. If Meta is using Strike 3 videos to train their content moderation tools on what adult entertainment looks like so that it can filter it out, that almost sounds like a fair use to me. That's an interesting one. Thank you for that, Walking Stick. Didn't Google win on the book index for improved searching? Yes. And there was recently a case in California where Judge Alsup said that the use can be a fair use. It can be transformative, and we don't automatically win copyright lawsuits against AI companies, against LLMs, because they ingested our stuff. It really depends on how it's going to be used. So yeah, Facebook Meta may have an out there if they are in fact making a fair use of it. But Strike 3 may be able to drag this lawsuit out and may be able to get them to pay a settlement. Anyway, that's all I have for you today. Let me know your thoughts in the comments below. I'm curious where this one's going to go, and I'll bring you updates as we go. Strike 3 will have an uphill battle here. Even in the book case, it was ruled the training was fair use. A judge said there was still a trial on the piracy for collection. Okay, so they may still be guilty of piracy in the collection of the thing, as they could have collected it in a different way. Especially considering they could have collected it by simply subscribing to Strike 3's properties for a couple hundred or a couple $1,000. Anyway, so let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney, and I'll see you in the videos that drop. Love you all. Bye-bye.